Welcome everybody to our session today. The session today is welfare overpayment allegations. My name is Kate Fish and I'm the online community manager for PovNet. I use she, her pronouns and I'm a settler of European ancestry. And did I hear somebody just holler? Just a reminder to folks to keep themselves muted if you are just joining. Thank you. Okay, and I'm a settler of European ancestry. I spent most of my life on the Tsimshian territory on the north coast and later the Syilx territory in the Okanagan. I'll be your moderator for today, so kind of guiding behind the scenes. This afternoon, I'm joining you from Courtenay, the unceded traditional territory of the Comox First Nation. This area is referred to as the Land of Plenty by the Comox people. Please feel free to share what territory you're joining from in the chat. So the goal of today's session is to help with understanding the welfare overpayment allegations and how to help clients respond and dispute. The session will also consider how to work effectively with the ministry's Prevention Loss Management Services branch. We are recording the first part of this session, but we will not be recording the Q&A portion near the end or the portion that the ministry is presenting on. However, the slides have been uploaded to Sched, so you'll be able to refer to those. Today, our presenters are Alison Ward, a lawyer for the Community Advocate Support Line at the Community Legal Assistance Society. We have Thea McDonagh. You can please correct me on that pronunciation, from TAPS or Together Against Poverty Society in Victoria. We have Jody Mogensen, the Prevention and Loss Management Services, who is a part of the Prevention and Loss Management Services for the Ministry of Social Development and Poverty Reduction. We also have Anita Lehue with the Ministry of Social Development and Poverty Reduction. And before I hand it over to Alison to kick things off, I just want to go over a few logistical details. So today we've got some people providing tech support. We've got Nikki and Anna, and they're available to monitor the chat and kind of keep an eye out if you require any technical assistance throughout the session. You can ask for support by just typing in the chat and letting them know that you're having an issue. You can also message them directly, either Nikki or Anna. Thank you both for providing this important service today. So if you do have any questions for the presenters, again, you can drop them in the chat. I will field any time-sensitive questions to the presenter as they arise. Otherwise, we'll save some Q&A time at the end. And at that point, you can also ask them via video live if you like. That'd probably be particularly helpful if it's a question that is a bit lengthier and more challenging to kind of type out. So those options will be available at the end. Okay, I think that's over to you, Alison.
Thanks, Kate, for that introduction. I was just taking a look at the participant list while you were talking, and I see that we have a real mix today. So we have some very senior advocates, and then we have some people that I know are new to this, to advocacy in general, and I think to overpayment issues specifically. I also know that I did work with a number of advocates this year who were handling their first welfare overpayment allegation file, and it was a reminder to me that this area can be quite tricky because there are a lot of sort of moving pieces that come together and that are important to know about if you're helping clients with overpayment issues. So what I'm going to do today is I've got slides prepared to really provide a high-level overview of what I like to call all those moving pieces and a reminder about some important advocacy points to keep in mind and legal points to keep in mind as you're working with clients through different aspects in dealing with overpayment allegations. After I've done that, Thea is going to work on a fact pattern and kind of try and bring it all together and show how do you apply all these pieces and keep all these pieces in mind when you're dealing with an overpayment related issue. Next slide, please. All right. So overpayment issues can really present in your office in 4 common ways. So you want to, just going to run through them very quickly. So you may have a client come to see you because they realize that they didn't disclose something they think maybe they should disclose, and it's causing them a lot of anxiety and worry, and they want to know, should they tell the ministry about something? And if they do tell the ministry, what can happen? Now that question in particular, we call it voluntary disclosure. That question in particular kind of means you need to know about the start to finish process about overpayment issues and what can happen and what possible consequences may apply to the client. So I think everything in the presentation today can relate back to that particular situation. Another way the issue can present is somebody comes in with a compliance review in Section 10 issue. That means they've received a letter from the ministry's Prevention and Loss Management Services branch asking them to provide information and verification and documents by a certain date to show that they were or are eligible for certain benefits. Next slide, please. They may also come in with a notification of overpayment letter. That's a letter that PLMS sends out when the ministry is thinking of assessing an overpayment. And that letter is part of the ministry's administrative fairness process, which provides the client notice that, look, we're thinking of assessing an overpayment for these reasons. Here's a draft overpayment chart that will also be attached to that letter, setting out what the ministry thinks the amount of the overpayment may be. The client will have the right to respond to that letter to provide more information. And there's usually a deadline set in that letter as well. And we're going to be talking about PLMS deadlines and how you can try and negotiate with PLMS for extensions in many situations. And finally, the last situation I think that's quite common is somebody will come in with an overpayment and notification decision. That's a letter from PLMS, which is with an actual finding that they owe an overpayment with an overpayment chart setting out a specific amount. I've said $8,000 in this situation. The client disagrees and wants to know if they can dispute it, and if so, how they would do that. All right, so we're going to start by looking at the question of legally what is an overpayment. So next slide, please. All right. So the employment and assistance legislation each of the acts has a section dealing with overpayments. And you can read the section yourselves. I've got section 27 of the Employment and Assistance Act up there. And I've underlined some key parts. So essentially an overpayment is a finding that somebody is not eligible for benefits that they've received, whether that's assistance, hardship, or a supplement. It's a finding that they're not eligible for it. And so really working with overpayment allegations, I want to just flag that it does require quite a thorough understanding of the eligibility criteria for assistance, because overpayments can arise in relation to many different eligibility issues. For example, does someone actually own an asset that the ministry thinks that is an excess asset for them, or are they a beneficial owner? If there's a spousal allegation and the ministry determines there was a spouse or alleges that there was a spouse, you need to have an understanding of that aspect of the legislation. So those underlying eligibility issues are beyond the scope of the presentation today. But I'm just flagging that, there are many aspects of welfare rules and eligibility that will come up in overpayment issues. The second thing to stress is that liability for overpayments is joint. So if a family unit receives an overpayment, all adults in the family unit are liable for the amount. If there's a subsequent change in the family unit, the overpayment remains with the I think the ministry uses the term main actor, something like that. So the person whose name the original file was in, who was considered the applicant on the file where the overpayment arose. The other thing I want to note is that subsection 2 of section 27 limits the right to reconsideration and appeal with respect to overpayment. So the limitation is with respect to the amount of the overpayment, and I just want to look a little bit more at what that means. So next slide, please. All right, so it says that the amount is not appealable under section 17.3 of the Act. If we look at section 17.3, we find that that refers to the right to appeal reconsideration decisions to the EAT. So does that mean that you can't appeal any decision about an overpayment to the tribunal? No. So what is limited is appeals about the amount of the overpayment, and we want here to distinguish between issues about the amount of the overpayment and the very existence of an overpayment itself. So you can apply for reconsideration of both those issues. If a client disagrees with the amount of an overpayment that's been assessed, it's been miscalculated, for example, they can apply for reconsideration of the amount. They can also apply for reconsideration of the existence of the overpayment. Basically, that would amount to arguing that I wasn't ineligible for this thing that they think I was overpaid. I met the eligibility criteria, and that would be the issue in the reconsideration. The limitation arises at the level of the tribunal. So reconsideration decisions about the existence, about whether or not an overpayment exists, can be appealed to the tribunal. The only thing that can't be appealed is reconsideration decisions about the specific amount of the overpayment. So of course, to apply for reconsideration or appeal of a decision, we first need a decision to appeal. So I'm kind of going to walk through the process that can lead up to establishing an overpayment decision and advocacy points for you to bear in mind during that process. Next slide, please. All right, so compliance reviews is what I want to talk about, because compliance reviews are what PLMS, compliance reviews are conducted by PLMS, and they are a process to confirm past and present eligibility under the regulations for benefits received or receiving. And so compliance review is basically an information gathering process where PLMS is trying to assess whether or not there was an overpayment or an underpayment, or if there's various results that are possible. So I think that Anita and Jody will be providing a lot of detail about this process in their presentation, so I'm going to go quickly. Cases can be selected for review, for compliance review at random, based on data matches. For example, someone's getting EI, but they never declared any income, wages to the ministry. Fraud allegations can be received from third parties. There's a fraud allegation reporting form online, and calls can be made to PLMS by third parties. And fraud allegations can also be received from other ministry staff. That more or less means, I think, where EAWs escalate an issue to PLMS for investigation because they think that there is a possible overpayment and potentially fraud. And then there are some cases where EAWs automatically refer cases to PLMS. EAWs can only establish overpayments to do with up to 3 months of assistance for the family unit. Cases about, so if it's an issue involving more than 3 months of assistance, it goes to PLMS. Cases with alleged spousal or dependency relationships, I understand, always go to PLMS. And if there's a prior client error overpayment on the file. Just to add one more thing, ministry error overpayments. So those are overpayments where the client reported correctly, but there was administrative error or an error in applying the law or policy in the ministry's behalf. My understanding is that those cases also don't go to PLMS, and that EAWs in that case are notifying clients of overpayments. And I stand to be corrected on all of this when PLMS presents later. So, but that's my understanding of the situation. Next slide, please. So there are a couple of basic principles, legal principles that apply throughout any dealings with the ministry, or specifically PLMS in dealing with overpayment allegations. So one is an administrative fairness. So the ministry is always required to provide its services in an administratively fair manner, which includes the right to notification of decisions, the right to reasons from any decisions, the right to respond, and that equally applies to PLMS. So, for example, where PLMS is issuing a request for information and verification of information related to eligibility, that Section 10 request process has to be done in an administratively fair manner. And again, I think that the minister will probably review the compliance review policy topic. It does have quite a lot of detail. As part of the advocate consultation process, there is a PLMS subcommittee that works on PLMS related issues. And I'm a part of that subcommittee. And over the last couple of years, we've gone through that process of when are letters, Section 10 letters sent out, what are the timelines for response, and it's set out in quite some detail in the policy, and I really encourage you to have a look at that. So now, there are some limits on what information and verification can be requested under Section 10. First, so only information that is strictly relevant to an eligibility issue can be requested. This is not a fishing expedition. There's legitimate requests for information relevant to eligibility issues. As you can imagine, it's very difficult to talk about that with any specificity because there are so many different eligibility issues that can arise, but you want to really keep in mind always, what's the relevancy here? Does this really need to be provided? Yes or no? Secondly, requests can only go back, cannot go back for more than 6 years. That's a limitation period issue because there is a limitation period for 6 years with respect to government debt under the Financial Administration Act. And then I also wanted to flag, this is now an old BC Supreme Court decision named Stowe. I've uploaded it to SCED so you can have a look at it. It is also available in CanLII. So that was a situation where basically it's an old case. It was under the BC benefits legislation, so it's quite different from the situation now. But a person who rented a room from a head tenant and was trying to get shelter benefits and provided rent receipts from the head tenant, which the ministry wouldn't accept, and insisted that he get a letter from the owner. The person didn't know who the owner was. There was no contact information. He was being required to obtain something that it was objectively impossible for him to produce. And so we have a couple of findings in that case about the fact that the ministry, quite logically can't require people to produce documents that in fact are an impossibility for them to obtain. So we also know that with Section 10 requests, many clients struggle to obtain documents requested, particularly on the timelines that may be stipulated in letters that ministry sent out. And so administrative fairness is relevant there because there may be situations where the notice that's given to the client is not adequate, or the client requires additional time to respond. And on top of the administrative fairness point, the ministry, of course, has a duty to accommodate clients that may struggle with such requests due to disabilities. And I think the ministry will talk about their deadlines internally more in their section, but if you look at the compliance review policy, it is quite liberal in terms of the ability to, it's important to communicate with PLMS and request additional time to get documents together and submit them if you have a client that's in that situation. And I believe PLMS is usually quite open to those requests. Next slide, please. So as I said, where a client is struggling to provide documents, respond by a deadline, or obtain a document that's been requested, it's very important to bear in mind that, of course, the ministry has a duty to accommodate under the Human Rights Code. That's a proactive duty that applies to the ministry at all the time, and that prevails over ministry practice, ministry policy, and ministry legislation. You know, the code is often referred to as being quasi-constitutional. So, of course, the code protects BC residents from discrimination in several areas, including the provision of services on enumerated grounds, including physical and mental disability, which I think are most relevant to the questions we're dealing with today. So where a client has a disability that's affecting their access to services, the ministry has a legal duty to accommodate their individual needs to the point of undue hardship, where, as I said, the need is based on disability. So undue hardship, generally speaking, is a very high threshold. Considerations of administrative convenience and cost are not really relevant usually to the determination of undue hardship. So it really means substantial accommodation in many situations. And of course, the duty to accommodate, as we've already talked about, is relevant to many aspects of compliance reviews and overpayment assessments. So as I've said, the compliance review policy has a lot of specific procedures and timeframes that it sets out. And the PLMS committee, in working with the ministry on that policy, really was mindful of trying to try and craft a process that would be administratively fair for clients. But we all know that reality on the ground does not always happen in accordance with policy that's written in a book. And so there will be situations where administrative fairness can arise, but you really need to be familiar with the policy process so you can spot which of your files might be going sideways and not in accordance with the way things are supposed to unfold. I'll reiterate that, if a client needs more time to get things done or submit documents, you should be contacting, I've got an acronym spelling mistake there, contacting PLMS and requesting it if the request is from PLMS, and from the ministry elsewhere if it's from the ministry. It's also super important to make proactive accommodation requests. If the client has a disability that's affecting their ability to deal with the situation, you need to be proactive in advising PLMS of that situation and asking for accommodation. I think that's really the best practice so that the client is not taken aback by too quick requests that they can't comply with, and there can just be a situation of miscommunication where PLMS is not aware of this client's specific needs. It's also important to bear in mind that PLMS does have the ability to have staff help obtain documents if needed. I think sometimes advocates take on a lot of work of getting information and verification documents together on the client's behalf, and that PLMS can actually do that in some situations as well. So bear that in mind where you think that might be useful for specific documents. All right, but at the end of the day, there are sometimes clients that don't have an advocate to assist them before they come to see you after they've been through a Section 10 process, and even clients where you're helping, but they may not be able to comply. There are sanctions that can, of course, be applied, and I just want to review those quickly. Next slide, please. So Section 10 sanctions apply to situations where information verification are not provided as requested, and the ministry has not received the documents or specific eligibility information they've requested. There's been an important change in the sanctions that are available under Section 10 on January 1st of this year. So prior to that, the only thing that the ministry could do, where it was of the opinion that there was non-compliance with Section 10, the ministry's only choice was to cut the family unit off benefits until it complied with Section 10, which is a very harsh consequence, of course. So as of January 1st, the legislation was amended, and now the ministry may either reduce a family unit's benefits by $25 a month or declare them ineligible. Both of those consequences would last until they're considered to be brought into compliance with Section 10. There's a further amendment as of January, which is that if someone is homeless or at imminent risk of homelessness, the ministry no longer has the option of cutting their benefits off under Section 10. So I think that it's possible that you may come across clients where they're not on benefits because they might have been cut off under Section 10, say last year. And they may, of course, be unaware of this change. So you need to be aware. If you're finding anyone off benefits, inquire, was it a Section 10 issue? What happened? Because the ministry can review sanctions, and maybe Anita and Jody can talk more about this, but my understanding is that if someone's in this situation, if the ministry is contacted, that sanction, the ineligibility could be reviewed. And if they are in fact homeless or at risk of imminent homelessness at the time, the ministry would look at ending that ineligibility and doing a process to restore assistance. Okay, so next slide, please. So after the compliance review process has happened, the ministry's got more information, or if they haven't and the Section 10 sanctions been applied, let's say they did get the information they needed. There are five possible results that can happen. So one is no change in eligibility. Eligibility was established. The person received everything they were eligible for, nothing more, nothing less. And that's a very neutral outcome. It may also be determined that the client received less than they were eligible for, in which case is an administrative underpayment. Or, of course, an overpayment may have been established. Under the welfare legislation, the client will be required to repay the overpayment. So if the overpayment is established, of course, they do have the right to reconsider and appeal if they so choose. Let's say they do and they are not successful, so the overpayment remains. In that case, then repayment will happen under the welfare legislation. There's a standard deduction now. We now have a minimum deduction and a maximum deduction specified for overpayments under the legislation, and they are both $10 a month. So the deduction will be $10 a month unless the client requests a higher deduction level. The fourth outcome can be that not only is an overpayment established, but sanctions can be applied. And finally, in addition, the case can be referred for criminal charges for fraud under the criminal code or under the welfare legislation. So I want to spend some time looking over those various consequences because, again, when a client, says, "Oh, I'm thinking of disclosing something to the ministry," what can happen if I do that? You need to be aware of all of these possible results. And this is where I say that it's a little hard to track this topic. So I'm kind of backing up in a way. So we've said one of the things that can happen is an overpayment can be established. So when we're talking about overpayments and consequences for overpayments, it's important to know whether we're dealing with an overpayment due to client error or to ministry error. As I said earlier, overpayments caused by ministry error can be situations where the ministry may have something was reported to them and it wasn't recorded, or they wrote down a number incorrectly, or they may have applied the law or policy incorrectly as well. And what happens as a result of those things is that the client receives benefits that they're not technically eligible for. So that's considered to be a ministry error overpayment. Under the legislation, Section 27 of the Act that we looked at earlier, all overpayments are treated the same, regardless of whether they're caused by client error or ministry error. Section 27 says basically, the client that if you receive benefits you're not eligible for, it's an overpayment. The cause of the overpayment is not relevant under that section. But the distinction between client error and ministry error is relevant for some ministry procedures and also for consequences. So as I said earlier, my understanding is that if it's a ministry error overpayment, it's handled by the employment and assistance worker. We can say safely that the ministry doesn't apply sanctions due to ministry error overpayments. Sanctions in this situation are for inaccurate or incomplete reporting. And by definition here, the client has reported correctly, and it's the ministry that has had an error. So there would be no basis for a sanction. And then this last one is important. For ministry error overpayments, it's also important to know that the ministry has an Estoppel Policy, which is kind of a defense to collection of an overpayment. So whenever there's an overpayment that arose because of ministry error, the ministry reviews the situation according to their Estoppel Policy, and I'm going to talk about that towards the end of the presentation. And if an Estoppel defense is found to apply, then that overpayment can no longer be collected or is not collectible. Right. So by eliminating the sanctions and overpayments with the sanctions and criminal charges with respect to ministry error overpayments, it means that we do need to look at the options or what can happen in terms of sanctions and criminal charges where an overpayment is caused by client error. Next slide, please. So for those of you that have been doing advocacy for a while, please bear with me here. I wanted to review some history so that advocates who are newer can be aware of the situation as it used to exist with respect to the welfare consequences where somebody was convicted of welfare fraud under the criminal code. There was a long period of time from 2002 until August 1st of 2015, so approximately 13 years, where if somebody was convicted of welfare fraud under the criminal code, there was an automatic lifetime ban on welfare eligibility, meaning they could never get income assistance or disability assistance, again, in British Columbia. There were some provisions for hardship assistance in compelling situations where there was risk to health. So in that 13-year period, about 185 people were convicted of welfare fraud. And I took that stat from a newspaper article. And I think that many of them may know that the lifetime ban on welfare eligibility has been lifted because they were off assistance because they had a lifetime ban. When the change in the law happened in 2015, the ministry didn't have their current addresses, and I think many people simply were not advised or aware of this change. So you may come across clients that have a lifetime ban, and they may think that they're still banned from receiving any welfare. And of course, that is not the case. They are eligible to apply for welfare as any other. They may have an offence overpayment they have to repay. But I think you also need to bear in mind that for clients who have been on assistance for some time, say a client is coming to you considering whether to make a voluntary disclosure to the ministry, they may be under the impression that there still is a lifetime ban that exists, and that may really influence their thinking and discourage them or make them very fearful of disclosing to the ministry. So I just want you to be aware of that history, because I think it does still have an effect on certain issues today. Next slide, please. So now this is the section where I'm really anxious to hear from Jody more, but there are two kinds of criminal charges, or charges that can be brought in relation to welfare benefits. Now, I'm not a criminal law lawyer. I'm just going to review this very generally. So the charges that can be brought are for fraud under the Criminal Code of Canada. Fraud, there are two categories of fraud, essentially. One is for fraud under $5,000. The other is for fraud over $5,000. The difference is the severity of the sentence that could apply if the person were convicted of fraud and were sentenced. A person can also be charged with the statutory offence under the welfare legislation, and that offence is knowingly supplying false or misleading information with respect to a material fact. So it's important to note that for both of these charges, guilty intent is required. When we talk about criminal law, or when you take a criminal law class at law school, you'll be told, okay, there's two things that make up a crime. One is the act, and one is so actus reus and mens rea. So guilty act and guilty mind is sort of the general way that's described. And so here, for anything related to fraud or supplying false or misleading information, there is an element of intent. So for fraud, there would have to be proof that the accused person acted knowingly and intentionally by deceit or falsehood to defraud. And similarly with the statutory offense, there's proof of intent that's required. So that is that the person knew the information provided was false or misleading. And so I think in many cases that advocates deal with, there are often clients who have simply misunderstood a situation or have been confused about their reporting requirements, or may well have a brain injury or their cognitive barrier or mental health issue that is the reason that they have not reported as immaculately as they possibly could. And that is the reason that underlies the issues that have come up. And it's not due to any guilty intent on their part at all. And so it is very important that if your client is in that situation and you're dealing with PLMS with respect to an overpayment, or you're considering a voluntary disclosure, make PLMS aware of any disabilities related to non-reporting or other mitigating circumstances, the reasons why the person had trouble, as soon as possible, so that the evidence of the client's lack of any criminal intent is clear right from the outset. Now, of course, I find that this is actually a very difficult area, in the sense that if a client has any concerns about possible criminal charges, if you say to them, well, there could be the criminal charge as a result if there's proof that you had a guilty intent. If the client has any concerns about possible criminal charges at all, you need to be referring them to a criminal lawyer for advice. It's important to know that from a criminal law point of view, any information that they voluntarily disclose to the ministry, for example, can be used against them in a criminal case. And so it's really a criminal lawyer that can be advising them, about whether that might be an advisable thing for them to do or not in particular circumstances. And I also want to reiterate that criminal charges, while they are serious, are relatively rare. I don't know if PLMS can provide us with any stats today, but I took a quick look through CANLI to see how many reported cases I could find for the past couple of years. And I found 1 in 2019 and 0 in 2018 and 0 in 2020. That doesn't mean that they didn't happen. There might be unreported cases, but that was the result of my quick search of CANLI. Just want to talk a little bit about procedure with respect to criminal charges as well. So the ministry can't bring charges against somebody. In BC, it's only Crown Counsel that can approve criminal charges. So what the ministry can do is recommend a request of Crown that charges be laid, and then it's up to Crown to make a decision. Crown Counsel, just in general, in all criminal cases, applies a two-part test. So first of all, is there enough evidence which, if believed, that there's a substantial likelihood of conviction of this particular offence? And second, is it in the public interest to lay the charge? So if you have a client that is in fact charged with welfare fraud or a statutory offence under the welfare legislation, you need to have them apply for legal aid right away. Legal aid views those charges as being basically a livelihood issue and will routinely appoint counsel where those charges have been laid. At the same time, most criminal law lawyers are not familiar with the welfare legislation. And so you guys as advocates are a very important source of help for them. If you have a client with charges who has a criminal law lawyer, it can be very helpful for you to contact them and offer to discuss whatever the welfare related issue might be so that you can help the criminal law lawyer understand the welfare legislation as it applies to the client's situation. Back in the day when there was a lifetime ban for welfare fraud, many of you will remember that criminal law lawyers didn't know that. The lifetime ban was located in the welfare legislation, not in the criminal code or anything that criminal law lawyers normally read. And they pled many clients guilty to welfare fraud, not realizing that that would have the effect of their client never receiving a penny's worth of regular income or disability assistance in the future. So we want to avoid that kind of unintended consequence that can arise from criminal law lawyers' lack of understanding of the welfare legislation. And so, of course, if a client is convicted of welfare fraud or a statutory offence, there will be a criminal sentence, which can include jail time and or probation or community service and other terms. In addition to that, they will also have an offence overpayment with the ministry. So that's a defined term. And I just want to run through the consequences of that quickly. And we're looking here now at, I believe it's section 89, if I'm right, of the Employment and Assistance Regulation. Next slide, please. So we're on convictions over offence overpayments 1. So this chart just lays out what happens if somebody has an offence overpayment. They've pled guilty or been convicted of an offence. The deduction that applies is $100 a month under the criminal code, and if the conviction is under the criminal code, that amount is deducted until the amount of the overpayment they were convicted with respect to has been repaid. The consequences where it's a statutory conviction are a little different. If it's a first conviction under the welfare legislation, it's $100 deducted a month for 12 months, and that escalates with the duration of that deduction escalates with a second statutory conviction or third statutory conviction. There is one exception to that deduction, which I've laid out in the next slide, please. So the exception to that $100 deduction is that the ministry has a discretion not to apply it in some circumstances. The most common being that the ministry is satisfied the family unit is homeless or at risk of becoming homeless, or they're satisfied that the $100 deduction would result in danger to the health of a person in the family unit. I believe that discretion also arises if someone's in a special care facility for extended care, or if they're in alcohol or drug treatment. So criminal charges are the most serious other consequence of overpayment issues that can arise, but they're not the only other consequence. As I've said before, there can be sanctions applied to a person's file for inaccurate or incomplete reporting. And I'm going to review that quickly. Next slide, please. So where there has been, or where the ministry alleges there's been inaccurate or incomplete reporting, the ministry has a discretion whether or not to impose a sanction. The discretion is found in section 15 of the Act, the Employment and Assistance Act, and section 14.1 of the Employment and Assistance for Persons with Disabilities Act. The legislation uses the word may, which always indicates that there's a discretion whether or not to do something. The sanction that is possible is a $25 reduction in the family unit's benefit rate. The duration of that reduction varies. If it's a first-time sanction for inaccurate and incomplete reporting, it lasts for 3 months and escalates from there. Second time, 6 months, third or more time, it is for 12 months. Next slide, please. So the decision to apply a sanction is not automatic. It is a separate legal issue. If an overpayment is established, the ministry then has to decide whether or not to apply a sanction. And in exercising that discretion, they have to exercise their powers reasonably, taking all relevant considerations into account. So of course, relevant considerations can include, somebody's mental health condition or disability or cognitive barriers or other reasons that led to the inaccurate or incomplete reporting. There's a sanctions policy that I've quoted there. So the ministry has a discretion to not apply a sanction where there are mitigating circumstances or the non-compliance is a one-time occurrence. So again, you want to be providing evidence of any extenuating or disability-related circumstances that the client experienced. Innocent mistake or confusion also should not lead to sanctions. So if there's evidence of that, that should also be led. And finally, a decision to apply a sanction can be reconsidered and appealed independently of any decision about the overpayment. So if a person agrees with the amount of the overpayment that's been assessed, but there's a sanction implied, they can apply for reconsideration of the sanction independently of the overpayment. Next slide, please. So this is the last portion of my presentation, and it's going back to something I talked about earlier. As I said, there's a lot of pieces at play, and they don't always flow, I found as I was preparing this in the neatest order. But I really want to bring to your attention the ministry's Estoppel Policy. So I've uploaded a copy of the Estoppel Policy to SCED because I find that it's a little hard to find in the policy manual. It's in the recoveries topic under reasons not to recover an overpayment. So what is estoppel? So estoppel is a legal concept that basically precludes somebody from asserting something that's contrary to what was implied by something they did before. So in a situation where there's a ministry error overpayment, which means that the client reported everything that they were required to report and they received more benefits than they should have solely because of ministry error, there can be an estoppel defense that arises. If an estoppel defense applies, that means that that overpayment cannot be collected. So there are 3 criteria, and I want to look at them one by one. So first, the recipient received assistance they weren't eligible for. And second, the ministry represented to the recipient that they were eligible for the thing they received. That could be by an explicit statement that they were eligible or by an implicit statement by the continued payment of assistance despite them having reported correctly. So there are examples given of what might fulfill this criteria in the policy that's uploaded to SCED. And there are some quite interesting ones. So for example, there was an example given of a situation where someone's receiving monthly nutritional supplement and they age off assistance and are moving over to medical services only. If a worker says, if the worker is aware of the situation and for some reason that monthly nutritional supplement remains in pay, there is an example of something that could be a ministry-related overpayment that's subject to the estoppel defense. And third criteria, the recipient relied on the funds to his or her detriment. So they received the benefits, they spent them, basically. They didn't, put them aside thinking, oh, I might have to repay this one day. So if you look at the policy, basically it says that there is in almost all cases an assumption that when someone's on assistance, that there will be detrimental reliance on the increased assistance. There's sort of an assumption that people will adjust their living expenses and spend that money. So those are the only three criteria. I want to talk a little bit about the process that's followed in determining whether an estoppel defense arises in a particular case. So next slide, please. The estoppel policy is doesn't arise from the welfare legislation. It comes from the Financial Administration Act, which is another provincial act. Section 87 talks about defenses to public debt. The policy is quite new. It's only been in effect since February of last year. And my understanding from the policy is that ministry staff are to proactively review whether a particular case of a ministry error overpayment meets the estoppel criteria, and that if an overpayment appears to meet those criteria, it's referred to a ministry supervisor, and there's also an estoppel review team, and that even that estoppel review team does not have final authority to make a decision, but because this process occurs under the Financial Administration Act, final decisions about whether a defense exists in a particular case are made by the debt management section, I guess, of the Provincial Financial Services branch. So I'm also really curious to hear more about how that works internally, because I think that this policy could be of great help to many clients who have ministry error overpayments. And I really encourage you to read the policy in detail, because I think that some overpayments that we may not think at first glance are due to ministry error are due to ministry error may in fact fall under this policy. And as I said, it is uploaded to SCED. So that is my section of the presentation. I'm just going to take a look at the clock. I think we're doing okay. At this point, I'm going to pass the mic over to Thea. If we could move to the next slide, please. We've got a fact pattern that she's going to gamely work her way through and see if she can apply all the things that we just talked about to the fact pattern.
And before I do that, I was just typing a question in the chat about the estoppel defense. And I'm just hoping, can you just confirm that the estoppel only applies to the overpayment? So for your MSO client you talked about, that person couldn't use that to say they should continue to get the nutritional supplement. They only can use that to say they don't have to repay the nutritional supplement. Is that true?
That's my understanding of the estoppel policy, that it applies to, an estoppel applies to a claim of debt. And so a claim of debt is by definition kind of backwards looking. It's not forwards looking to try and establish an entitlement. So you would argue estoppel with respect to the debt. There's no easy argument to argue that they would remain eligible for M&S going forward.
Okay, thanks. I just wanted to clarify that. So I'm going to go through a quick fact pattern. A lot of it is going to be repeating what Alison's gone over, but it'll put it into context of if you have a client come in with one of these issues. So I'll read out the fact pattern, and then I'll just kind of go through the steps that I would take if this was my client. Again, some of this will be pretty elemental for some of you in the audience, and then for some of you who maybe haven't come across this yet, it might be useful. So bear with me. So Walter Brown contacts your office because he is worried that he is not filling out his monthly reports properly. During your intake interview, you learn that Walter is a single man who lives alone and has the PWD designation. Walter tells you that he has been working as a delivery driver for Skip the Dishes and DoorDash since February. This is happening now, so let's just say it's today. When asked, Walter tells you that he has not been declaring his earnings as he does not have any pay stubs and was confused by the monthly report. Walter does not know exactly how much he has earned, but believes it was between $2,000 and $2,500 per month. Walter also tells you that he originally applied for PWD due to a brain injury that left him with long-term cognitive impairment. So I had originally had this fact pattern set up, and if we weren't on Zoom, it could be more interactive. But for today, I'll just sort of go through the steps that I would take. So the first thing I would do is get more information from Walter, and there's some specific things that I would want to know, and some specific documentation that I would want him to get. So I would want some more information about how his disability impacts him. So as soon as I know that he's PWD and he's had trouble with this reporting, going back to what Alison was saying, is there an accommodation issue? I'm just going to find out more about his disability. Is his memory impacted? Does he have trouble with comprehension? He said that he found the monthly reporting confusing. So I'm going to gather some more information about that. I am going to find out whether or not the Skip the Dishes and DoorDash is the only income that he has earned this year, whether he's reported it or not. So I need to know whether he's reported other income, because I'm going to be trying to figure out how much of his annual earnings exemption he has used. And I also want to know if he's had problems with reporting accurately before, because when we comes time to look at sanctions, I want to know if this is the first time it's happened or not. And then I'm going to look at getting some documentation. So we really want to get some documentation of his earnings. He doesn't have pay stubs, but it's really helpful if those earnings can be broken down by month. Again, when it comes to calculating his AEE, his earnings exemption, we want to know if he exceeds it, when he exceeded it. So it's helpful to have what he earned in each month, as well as more like documentation regarding his health condition or his disability. That could be a doctor's letter. He's applied for PWD. Maybe he has his PWD application. I don't know about the rest of you, but we often have clients have accessed our office to apply for PWD. So sometimes we even have a record of their application, and there's often really great information in there. Sorry, I skipped over the documentation for earnings. That could be bank statements, receipts. Some people keep personal records if it's like self-employment income. So that's some of the information gathering stage. And then I'm going to need to give Walter some information about what he can expect. So without having all the documentation, a pretty conservative estimate of his earnings, if we go with the lower end of $2,000 a month for 9 months, puts him at $18,000. So it's pretty likely, well, he's going to exceed his AEE. And realistically, it's probably going to be between $6,000 and $9,000 over his annual earnings exemption for the year. That's if he had no other income, and we're just talking about this delivery income. So I'm going to need to tell Walter about the potential for a sanction. So a sanction can be applied because it's likely he's going to have an overpayment, right? So if he had only earned, say, $9,000 that year, and was still within his annual earnings exemption and there was no overpayment, then there would be no sanction. But because we can pretty safely say he's going to have an overpayment, then I'm going to tell him about the sanction possibility. If it's his first occurrence, as Alison said, it would be a reduction of $25 a month for 3 months. However, to repeat again, applying sanctions is discretionary. And if his challenges with reporting are related to his disability, we will be requesting that no sanction be applied. I also need to let Walter know that if the ministry has reason to believe that his lack of reporting was intentional, they can pursue charges. And that's what Alison talked about. That can be either under the Act or under the Criminal Code. If this was the case, I would be referring him to legal aid. And then just a note that in that scenario, it's a good idea to ask Walter if you want to add that lawyer to whatever consent form you have on file, so you can be helpful, like Alison was saying, with just taking those two pieces, how it's going to impact his welfare. So, but the fact that Walter has a cognitive disability, and he's already shared some of that with me, and I know that comprehension is one of the issues. I also know that impacts his memory, really helps establish a lack of intent, and therefore that information becomes really important. That's what Alison already went over. If he was convicted, then the rate would change for the sanction, but we already know that. So then I'm going to tell Walter what I can help him with. So I can help him compile all the documentation regarding his earnings. Often people find that a really daunting process. So you might have had people show up with a big stack of stuff and need help to sort of sort through it and create, make some sense of it. If Walter is unable to get that by himself, there's a couple options. You could try and request it for him. You can also assist by requesting that the ministry verify that information for him. So if Walter can't go to the bank for some reason, but says that he's looked at the records online or whatever, or he thinks it's about this much, then you can ask that the ministry verify that information. Once we have the documentation about his earnings, I always do the calculation myself first. So this is what I believe your overpayment is going to be. And then I put all that information into a service request and submit it for Walter. There's different ways you can do that. You can present the ministry with your calculation of the overpayment and basically spoon feed it and say, this is how we've calculated it, and see if they agree. You can also just disclose the income and let them calculate an overpayment. Either way, it's important to double check that your calculation matches theirs, because sometimes mistakes are made. And then your service request needs to very clearly include information regarding your client's disability, including why a sanction would be inappropriate, an accommodation request if applicable, and it should clearly outline how the client's disability prevented them from meeting their reporting obligations and show that lack of intent to mislead or defraud. So that's the steps I would take. I don't know if we want to, I think that's the end of my and Alison's part. I don't know if we want to do any questions now or just keep moving. I'll let Alison sort of determine.
Yeah, I'm going to suggest that if I don't see any questions coming up, I think that we're going to learn more as we move through the ministry segment. So I think that saving questions for the end would be best, but that Thea and I will be available then too, if that works. Unless if you have a burning question, please put it in the chat now and we'll see. But I think otherwise we will move on to the ministry portion of the presentation.
That sounds perfect.